Hello and welcome to my next blog. I'm sitting in my granddad chair, talking about the Housing Grants and Regeneration Act. It is a piece of legislation which I believe was brought about to deal with payment issues between client, main contractor, subcontractor and suppliers. And it's, I think by all accounts, is a reasonable legislation. However, it has a lot of complexities, specifically in regards to notices, defects, and the like. Now, one thing from a client's perspective is make sure that you're versed in the Housing Grants and Regeneration Act. Specifically, you've got to look at one section as notices. Very, very, very important because it's very, very strict. You could have the shittest builder on site and still be liable for payment if under contract you're working under the Housing Grants and Regeneration Act. So it's extremely important that your architect, PQS surveyor, I'm pretty confident they would know about it, as regards to notices. And where it gets even more complex is, for example, if you've got a shit builder, you need to allow them the opportunity to remedy their shit work. If you don't allow them that opportunity, you're still responsible to pay that bill. So it's just very important you comply with it, because you may be in a very dire situation, and you just want to push on, but sometimes pushing on is going to even cost you even more money. So it's very important that you, as a client and as a builder, because it passes down the line. So if your subcontractor is also a shit subcontractor, you need to allow them to comply to bring it up to the standard that is required in the contract. So I suppose it puts everybody on their toes, but it is extremely important, especially if you've got people that understand this act. So anyway, I'm going to talk about it here in to where it gets very, very formal. But it exists. You can't ignore it. If someone brings it up and you haven't complied for it, say lovey, it's your problem.
Blog number 11, the Housing Grants and Regeneration Act. What is it? This is legislation is law which was brought about largely to deal with payment issues and disputes in the construction industry. It's complex legislation, and if you followed my prior blogs and followed my guidance, and you end up in having to rely on this legislation in an unfortunate position, you end in a dispute. You would by all accounts to be able to account for yourself and hopefully settle any issues. I never recommend having an appetite for going to court, but always prepare as if you were going to court. I mentioned previously in one of my blogs, a contract is irrelevant and never needs to come out the drawer once signed unless you need to rely on it. Most projects, the contracts just gather dust, but when you need the contract, boy do you wish to comply with it. Herein I discuss high-level details about the Housing, Grants and Regeneration Act. This is not exhaustive. The Housing, Grants and Regeneration Act, what you need to know. The Housing, Grants and Regeneration Act 1996, HGRA, is a UK law that aims to improve the payment and dispute resolution processes in the construction industry. It applies to all contracts for construction operations, which include a wide range of building and engineering works. The HGRA has been amended by the Local Democracy, Economic Development and Construction Act 2009, which introduced some significant changes to the payment and adjudication rules. In this blog post, we will explore the pros and cons of the HGRA and its amendment, and how they affect the parties involved in construction projects. The pros of the HGRA. The HGRA has several benefits for the construction industry, such as It ensures that payments are made promptly throughout the supply chain, by requiring the parties to agree on payment dates, amounts, and mechanisms. If the contract does not specify these details, the default provisions of the scheme for construction contracts, the scheme, will apply. The scheme is a set of regulations that supplement the HGRA and provide fallback rules for payment and adjudication. It introduces a fairer payment regime by banning a pay-when-paid clauses, which make the payment to a subcontractor conditional on the payment from a higher-tier contractor or the employer. Such clauses are ineffective under the HGRA unless the pair becomes insolvent. The HGRA also allows the payee to suspend its work in case of non-payment, after giving a notice to the pair. It makes adjudication more accessible for the resolution of disputes, by giving the parties the right to refer any dispute arising under a construction contract to adjudication at any time. Adjudication is a fast and cost-effective way of resolving disputes, as the adjudicator must give a decision within 28 days, or a longer period agreed by the parties. The decision is binding on the parties until the dispute is finally resolved by litigation, arbitration, or agreement. The HGRA also requires the parties to include an adjudication clause in their contract, or else the scheme will apply. The cons of the HGRA. The HGRA also has some drawbacks for the construction industry, such as it creates complexity and uncertainty in the payment process by introducing new concepts and terminology such as payment notices, pay less notices, and final date for payment. These terms are not defined in the HGRA, but in the scheme, which may not reflect the commercial reality of the parties. The parties may also find it difficult to comply with the strict time limits and formalities imposed by the HGRA and the scheme, especially in large and complex projects. It increases the risk of disputes and litigation by giving the parties more opportunities to challenge the payment and adjudication decisions. For example, the pair may dispute the amount or validity of a payment notice or a pay less notice, or the payee may dispute the jurisdiction or impartiality of the adjudicator. The parties may also seek to enforce or challenge the adjudicator's decision in court, which may prolong the dispute and increase the costs. It does not cover all types of construction contracts and operations, by excluding some engineering projects, such as mining, nuclear, and power generation, as well as contracts with residential occupiers. The HGRA also does not apply to contracts governed by the law of another country, even if the construction operations take place in the UK. Conclusion. The HGRA and its amendment have brought some significant changes to the payment and dispute resolution processes in the construction industry. The HGRA has some advantages, such as ensuring prompt payment, introducing a fairer payment regime, and making adjudication more accessible. However, the HGRA also has some disadvantages, such as creating complexity and uncertainty in the payment process, increasing the risk of disputes and litigation, and not covering all types of construction contracts and operations. Therefore, the parties involved in construction projects should be aware of the implications of the HGRA and its amendment, and seek professional advice if necessary. Warm regards. Brad. My blog joke: 2 hunters are out in the woods when one of them collapses. He doesn't seem to be breathing and his eyes are glazed. The other guy whips out his phone and calls the emergency services. He gasps, "My friend is dead. What can I do?" The operator says, "Calm down. I can help. First, let's make sure he's dead." There is a silence, then a gunshot is heard. Back on the phone, the guy says, "Okay, now what?"